Well, good morning, class. I say that every year. Welcome to our What's New in Estate Planning for 2025. Personally, I'm having a hard time accepting that it actually is 2025, but here we are. I'm Roberta Robinson. I'm the attorney who started this firm. I'm in practice with Daniel Wilson, a wonderful attorney who's also my son. I am not biased. And we are going to be talking about what is new. On the next slide, you'll see our obligatory disclaimer where we say we are discussing in general what the new law is. If you want to know how it applies to you specifically, please call us, email us, talk to us directly. I started practice 47, almost 48 years ago. Our office is in Rancho Bernardo. I'm a certified specialist in estate planning, trust, and probate law, which is a California board certification. And I'm in partnership with Daniel, and I have 5 wonderful grandchildren, not just Daniel's, also another son. Daniel, would you like to introduce yourself?
Yeah, so my name is Daniel Wilson, and I've been practicing now for over 12 years here at our office. And we are located in Rancho Bernardo, so North County, San Diego. And I do have a certified specialist in estate planning, a master's of law in taxation, part of the Rancho Bernardo Community Foundation. And so this is, purely what we do is estate planning, where we will set up your estate plan of creating wills and trusts and powers of attorney. And we also modify existing estate plans. So if you have an existing documents with us or somebody else, we can update them all the way through to the point of sort of executing the estate plan of handling trust administrations and probates. And so we're going to talk today about kind of recent changes in the tax law. So I know we have a big sunsetting period coming up, so we're going to go over that and also go over some changes in sort of how we think about estate planning. And so there's cases that come out every year relating to estate planning, and we try to take a look at them to see, has anything that's gone through litigation, what can we learn it from the estate planning perspective and try to avoid those situations in the future. And if you do have questions, you can ask them through the program and we'll try to answer them as we get to it. If we don't get to it, you can still send us an email afterwards. And we are going to be putting the slides and there's going to be an expansive handout in the chat so you can download that. And after the presentation, you will receive a link to watch the presentation or forward it to someone else, along with, again, the slides and the handout as well.
So, the first thing we're going to talk about is the federal estate tax exemption. And if you've attended prior seminars, you're probably thinking, why are you telling me about this? You've been telling me about this for 10 years. How much can I leave tax free without having a death tax at my death? This year, believe it or not, it's 13.99 million tax free, which I may start saying 14 million because it is easier to say it. So I can have a very sizable estate, leave it to my children, my grandchildren, and there will be no estate tax if I'm under that number. If I'm over that number, there's quite an estate tax. 40% of the amount over the exemption would be going to the federal government 9 months after my death. Well, what's happening next year? Finally, after 10 years, this tax law is set to expire or to sunset. And we're going to go back to what the law was before this tax law, and we will have about a $7 million exemption. It'll be half of what it currently is. For you technical people, that's 5 million plus the cost of really increase from inflation. So we're facing this, you might say, a precipice or a cliff that the law is going to substantially change next year. So let's take a look at what does that mean? Well, this year, my example is if I had a death in 2025 with the 13.99 million, there would be no federal estate tax. But next year, with the same size estate, the estate tax after my death would be $2.76 million. That's the 40% that's being taxed. So what's happening? This is the 2017 Tax Cut and Jobs Act, which you probably remember known as the Trump tax bill passed in 2017. It lasted for 10 years. This year, there's going to have to be a decision on what's going to happen to this tax bill. What are the options? And boy, this will be in the news. One option is that nothing happens, which could be because they need the revenue, so let the tax bill expire. It could be because Congress can't agree on a revised tax bill, but it's possible that nothing will happen and the exemption will be $7 million next year. What's another option? Congress could agree to extend the tax bill. So let's have 13.99 plus inflation starting next year, and we just kind of smoothly go along with what the law is right now. Third option, there could be a new tax law. Oh, I'm going to have to do so much reading if there's a new tax law. But it's possible. There's no rule that they have to go back to what already was. There could be a new law. So that is the sunset. I tried to pick a picture of one of our more beautiful sunsets here. So the Tax Cuts and Job Act is sunsetting.
And it's important to remember that that the tax only occurs in the event of your death. So we're focusing on, how can we plan around it while you're alive? But we know for some people, maybe a married couple, that a husband or a wife have already predeceased. And so, what happens with their exemption? So, let's say between a married couple, the first spouse died maybe a few years ago. And we thought at the time, because the exemption was so high, it was 10 million, 13 million, a really high number, that your estate wouldn't be taxed upon your death. And so we kept it simple to say between a married couple, the first spouse dies, don't really need to do anything. But now the surviving spouse, they live, their assets have appreciated. And maybe what seemed like not a huge estate at the time of maybe $5 million dollars or something has now gone up to 7, 8, 9, $10 million dollars. And now they do have what could be considered a taxable estate. So if their estate has continued to grow and the exemption has decreased because the laws are expiring, now there could be a tax at their death on the amount over the exemption. And so there is an option, and we know there's lots of CPAs and financial advisors that attend these presentations. So this is something to keep an eye out on for your clients, is to think, well, if maybe the first spouse has already died, what could I have done to get that exemption amount added onto my own? And so each person, as a married couple, has their own exemption amount. So this year it's 14 million. So I have 14 million, my spouse has 14 million. Between the two of us, all of our assets combined, we can leave up to $28 million free of the state taxes if we were to both die this year. But again, starting next year, if the law just sunsets, the exemption goes down, now me and my spouse and I will have 14 million as a couple to be able to leave free of estate taxes. But what if my spouse died again a few years ago? They had their exemption and it could have been $12 million dollars. I don't really get the benefit of that automatically. So now, upon my death, I just have my own exemption to see if all of my assets are above or below that, unless I file an estate tax return. So this is an optional return that the first spouse could have filed after the death of the first spouse to elect portability of the deceased spouse's unused exemption. So again, this year, if that first spouse died, it's that 13.99. And again, either it goes away if I do nothing, or I can file an estate tax return, get that exemption added onto my own. So even if my exemption in my lifetime goes down to 7 million, I still get another 14 million on top of that excluded from estate taxes upon my death. And so by filing this estate tax return, I get my spouse's unused exemption. And again, for a lot of people, maybe they didn't think they needed to file this estate tax return because they thought their own exemption would be plenty enough to keep their assets out of an estate tax. But fortunately, you do have some time to file it. Normally, it's 9 months after the death of the first spouse. However, with so many people probably being in this situation where they wish they would have filed this estate tax return, maybe they didn't know they had to, or they didn't talk to an attorney, or their advisor didn't advise them to do it. Because so many people wish they could have filed it, instead of that 9-year deadline, it's actually been increased going back 5 years. So now, in the event of a married couple, the first spouse died less than 5 years ago, you can still file their estate tax return to elect portability of their exemption. So again, if you didn't think you had to file it at the time, now would be something to think about of whether it makes sense to file this estate tax return just in case the exemption does go down and stays down in your lifetime. And of course, what are some other planning options that we can do again before the exemption does go down? Is you could use it up. So again, we have right now per person this $14 million exemption. You could use it up. Well, how do you use it up in your lifetime? Is you make very large gifts. So you have to really give away more than what's going away. So if you can gift more than $7 million, you could get the benefit of spending down your exemption. The reason that you have to give more than what's going away is it's spent from the bottom up. In that, let's say the exemption is going to go down and I give away $1 million as a gift. Well, now that lowers my estate tax exemption amount now from what could be 14 million down to 13 million. But really what I've done is if the exemption goes down, my estate tax exemption has also decreased by $1 million. So I really haven't gotten the benefit of giving it out, taking it out of my estate unless I give more than the 7 million that's going away. So you see that fat separator, when you pour it out, it's spent from the bottom up. And that's definitely something to speak with an advisor about if you're thinking about giving away more than $7 million worth of assets.
So what if you are going to give away this enormous amount, 13.99? You have to file a gift tax return. You have to report it. It's due the year after you make the gift, April 15th. And there's been a ruling that if you give away one of these enormous gifts and you spend that exemption before it expires next year, it's gone. You gave it away, no problem. You used it. Well, that's a very large gift. Most people kind of stick to maybe annual gifts. The annual gift that you can make starting this year is $19,000 per person. So I could give everybody on this Zoom $19,000. Oh, that would be quite a bit. This is our most widely attended Zoom, but I can give it away. I do not file a gift tax return. I do not get a deduction for giving it to you, and you do not claim it as income. It's an annual tax-free gift, and it does not cut into my exemption, my 13.99. So lots of people do this. They give gifts to their children, their grandchildren, maybe their in-laws. So you can give quite a bit away. And a married couple is two people, so they can each give $19,000, even to the same person, to the same child. So that would be a total of $38,000 each. That's a very large gift. So that's a good thing. What else can you give away and it does not use up your exemption? You can pay somebody else's medical bills or their educational expenses if you pay it directly to the provider. So I don't give it to my child. I don't give it to my grandchild. I'm going to pay, I'm just dreaming Harvard or Stanford to pay for their education. I pay it directly. It would be a lot of money. Or I have an aging sister maybe who needs help with medical care. I don't give her the money. I just pay the medical bills directly, unlimited. Now, when you make a gift, let's say you make a gift of cash, very straightforward. But let's say you give away some stock. So here's my favorite example. I bought Bitcoin, the new cryptocurrency, in 2017 for $1 a share. And today, believe it or not, it's worth $99,000 a share. If I own that Bitcoin at my death, all my capital gain, the difference between $1 and $99,000 goes away. My children or my heirs start with a new stepped up basis, date of death value. But if I give away the Bitcoin So I'm going to give you, Danny, I'm going to give you all my Bitcoin. You're stuck with my $1 basis. And if you sell it, you're going to report all that capital gain. So when we're strategizing, how do we make gifts? We want to keep, ideally, assets with a low basis and gift away assets that already have a high basis.
Just when you thought you were done with thinking about some taxes that could be due at death or in your lifetime, there's this sort of often overlooked or maybe not well known tax called the Generation Skipping Transfer Tax, or what we've referred to as a GST tax. And so this is a tax that could be imposed on either your estate or on a gift if you make large gifts to people below a generation below the children. And so there's sort of a couple ways to think about it. If you wanted to just make a gift to your grandchild, in a way you're skipping over your child's generation and giving it directly to the grandchild. So same thing as you have certain amounts you can give free of estate taxes or free of a GST tax and sorry, a gift tax. But also some people will set up their estates to say, well, I want to leave my assets to my children so they get the benefit of it, but I want it to be able to pass along to the next generation, so to their children, my grandchildren. And so they'll set up these trusts that stay in existence for the rest of their child's lifetime. So you say, upon my death, my assets stay in trust. The beneficiary of that trust are my children. For the rest of their lives, they can use the money for their needs and support, or it's, broad or limited what the money can be used for. But upon their death, it has to go to the grandchildren. So that's what we call a GST trust. And so for estate tax purposes, we're thinking, well, we're skipping over a generation because no matter what that trust grows to in my child's lifetime, upon their death, it's not taxed again. So from the eyes of the IRS, they're getting skipped over the generation by being able to tax it upon the child's death. And so we think when you set up those trusts, so when the parent dies, is that trust going to be taxable for GST purposes? And it's the same threshold. So we have our estate tax and the GST tax exclusion amount. They're the same of this year, 13.99 million. And so it's another tax that we have to think about when we're setting up these estate plans for multiple generations.
Here I am back with income taxes. You'd say, Roberta, why are you telling me about this again? You just told me about stepped up basis at death. Why are we talking about it again? It's very important. We find with the very large estate tax exemptions, most people are not having estate tax problems, but everybody has to pay attention to income taxes and what happens at death. It affects everybody. So what do we know? If I have an asset that appreciated, maybe my family home, maybe I bought it for $400,000 and now what? A San Diego house at least is worth $1 million. Can you believe it? So everybody has this large gain built into their residence. Maybe you've made good investments in stocks and those have gone up. Well, if I sell during my lifetime, I've got to deal with all this capital gain. I have certain tax breaks if it's my residence, but there is all this capital gain and I may owe a capital gains tax. But if I own these assets at my death, they get a new basis, the capital gain is wiped out, and the children could go ahead and sell without paying tax on gain. And I'll give you an example. Lots of times, well, many times, I have a child call and say, we have to move mom to a nursing facility. We want to simplify everything. We're going to sell her house right now. And I go, whoa, 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 let's talk about this. If you sell it now, you have to deal with the capital gains tax. If you hold it and it's sold after her death, I hate to be so cold hearted, but if it's sold after her death, all that capital gain will be wiped out. So you have to know that these rules exist. Certain things don't get a new basis. Those would be retirement plans, IRAs, pensions. Every dollar that comes out, if it's in your life or at your death, it's ordinary income. And also annuities do not get a new basis. But we all have to pay attention to basis planning. Now, here's an interesting development. Before 2010, you don't need to remember the date, but before 2010, we could not transfer a decedent's exemption directly to their spouse. It didn't exist. That portability that Daniel was talking about, making the election after the first death, it didn't exist. That was a relatively new idea. So, in order to preserve the two exemptions, husband and wife both have an exemption, we had to create what was called an A-B trust. So, if I were to die, my half of the estate would stay in trust for my spouse. It wouldn't go directly to my spouse. We'd use my exemption for that trust to protect it so that it wouldn't be taxed when my spouse dies. Great planning when estate taxes were so high, the exemption was so low. But what are we seeing now? Sometimes we're meeting with a spouse who has survived their husband or their wife for a long period of time, sometimes 20, 30 years. There might have been a premature death. And now we still have the AB trust. Trust B has an enormous amount of gain in there, especially if it was a La Jolla property. So it's really grown in value. And now the survivor comes in and says, when I die, everything's going to get a new basis, right? And I say, no, what you own in Trust A, what you own will get a new basis, but you don't own what's in Trust B. It won't get a new basis. And people are saying, wait a minute, I was trying to do the best tax planning I could do. Now I won't have a federal estate tax because the exemption's so high. I wish that Trust B would be in my estate so that Trust B gets the stepped up basis at my death. Well, there's actually a way to make that happen. And I've had a few of these cases this year. Daniel, I know, has had a few of these cases. We file a petition with the court and we say the intent of this couple was to do the very best tax planning because we have a new exemption and because the survivor has lived so long and there's so much gain in Trust B, the best tax planning now is for Trust B to be taxed when the survivor dies. What do we ask the court to do? We ask the court to modify the trust, add really a sentence to the trust. And that sentence, if it's written correctly, we'll talk about what it is. We tell the court, please add that sentence to Trust B so it will be taxed when the survivor dies. What is the sentence that we can add? The smallest sentence that we could add, you might say, is to say Trust B is subject to the creditors of the survivor when the survivor dies. In the eyes of the federal government, if that sentence is in the trust, that trust is included in the survivor's estate. We don't have to say the survivor is going to change the distribution plan or anything else, just that it will pay for the survivor's creditors, all the debts. The biggest sentence we could put in that trust is to say that trust is revocable by the survivor, completely undo it and have it be included in the survivor's estate. So who's going to recognize this issue? The CPAs, the financial planners. You're meeting with a surviving spouse who still has a Trust B, and you're filing a tax return for Trust B every year. You need a light bulb to go off and say, is Trust B so big? Does it have so much gain? We need it to be included in the survivor's estate. So heads up to the CPAs.
And also, if you're a married couple and you're both still alive, make sure you
Yes.
review your trust to make sure if you don't want to have those AB trust provisions in there, that you update it to take it out so you can change the structure of the trust while you're both alive.
And I think we can go past this slide because I already talked about it. All
Okay.
right. One more thing for income taxes. There are other forms of irrevocable trusts. So there is this Trust B, and it has to file a tax return itself, a special trust tax return, and falls under certain tax laws. Some people also create trusts for their children, ongoing trusts to provide for their children. One day that will go to the grandchildren, called generation skipping trusts. This is the world of irrevocable trusts. and there are special tax laws that apply to irrevocable trusts. And what I want to talk about is what happens to the income inside of an irrevocable trust. So that could be interest, it could be dividends. Is it taxed to the trust? Is it taxed to the beneficiary? Well, the news is if it's taxed to the trust is in the very highest income tax bracket with not much money, with only this year $15,650 of interest or dividends. Once it's over that amount, if it's accumulated in the trust, it'll be taxed to the trust at 37%. And in California, we've got our top rate of 14.4%, et cetera. It's a big tax if it's accumulated in the trust. But if it's distributed to the beneficiary, the trust gets a deduction. It goes to the beneficiary and shows up on the beneficiary's income tax return. And the beneficiaries, I'm reading now, they can have like over $600,000 worth of income before they're in the highest tax bracket. So in distributing income from an irrevocable trust, trustees, you want to meet with your CPA before the end of the year to get an estimate of how much taxable income is in that trust. And you're going to ask your estate attorney, can I get it out of that trust? And the estate attorney will look at the trust and see, does it say income must be distributed to the beneficiary? The answer is yes. Does the trust say income may be distributed to the beneficiary for reasonable support? Well, as long as it's reasonable, yes, it can be distributed. So planning for the income taxation of irrevocable trusts is a very big deal. And again, I'm telling those CPAs and financial planners, you're probably the ones who are going to catch this. So heads up on that point.
And even though we are recording this or presenting this at the beginning of the year in January, if you do have an irrevocable trust and maybe you did have some income, accumulated in 2024 last year,
Yes.
maybe it is you do have actually 65 days after the end of the calendar year, so that gets us closer to like March 5th to get all the income that came in from 2024 and get it out even on that tax return. So if you're in February and you see, oh, there's a lot more income than I thought maybe was generated within the trust last year, even though it's past the end of the calendar year, you still have an opportunity to get it out and have it apply to last year's taxes so that the trust doesn't pay the taxes on it. So talk to your CPA about that. Okay, well, what else is new? Again, in estate planning, we're very conscious of how do you sign documents. So this is actually really big here in estate planning and even in California, that there's very specific formalities that you have to follow to make sure your estate planning documents are valid. And so kind of a lot of the main question we get talking about signing documents has to do with, well, can I just electronically sign my estate plan? And we say, no, not in California. So an electronic signature, DocuSign, Adobe eSign, basically where you just, you open up a document on your phone or your computer, click a couple buttons and it puts your signature on there. We don't have that in California for estate planning purposes. And so we still have, kind of pen to paper to make sure the documents are validly signed. Because you know, if you sign your estate plan electronically in California and it's not recognized, it's as if it was never signed to begin with, and you get yourself in some hot water. Of course, there are other states that do allow electronic signatures on wills. So Colorado, Utah, North Dakota, Oregon, Washington. But again, not in California. So it's very important to keep in mind that if you're doing your estate plan, even if you're working with one of those online services to do the estate plan, there's, a lot of them these days, the DIY ones, that they may still require you to physically sign your documents, and hopefully you follow the proper signing procedures. Although it is possible to have certain documents notarized or signed electronically while you're in California if the notary is out of state. So there are other states that, again, allow electronic notarization, not in California, where basically you are video conferencing the notary, they're in another state, and you show them, your ID, you sign the documents in front of them, you mail them the documents, they notarize it, and they send it back to you, so that does work in other states, but again, you should be very cautious when doing something like that. But what do we have now in California that's new about electronic signatures? Has to do with recording documents that have been signed and notarized sort of electronically. And so in California, of course, when you buy a house, you can DocuSign, you can purchase the whole property and do it all off your phone, and even notaries can, do it electronically. One of the big questions, though, is can you record your deed electronically? And in California, some counties allow it. So here in San Diego, we can actually upload to the assessor's office deeds to be recorded. And so we may have the wet signature document, but we're scanning it and sort of emailing it to the assessor's office, and that can be accepted to be recorded. However, not all counties and not all in California allow this. And so under this new law, it says that if the county doesn't allow electronic recording of original documents or of e-signed documents, then there is a procedure to follow. So basically, you sign the deed electronically, you get a disinterested custodian. So this is kind of the term in the law now. There's a disinterested custodian that will print out the document and then sign sort of a notary acknowledgement saying, yes, this was electronically signed. I'm notarizing it that I printed this out. And then now they can sign sort of the tangible copy with that new notarized certificate. So it's just another option. It's again important these days that some people are able to like record deeds sometimes very quickly. And so this is just another option that we have if some people it's difficult for them to get out of the house or to arrange a notary to come to them, that there are other options for recording electronic signatures.
So you can see by virtue of the fact that we're on Zoom, the world has changed post-COVID. And I think the whole issue of electronics and communicating through electronics is just going to explode on us. We're at the very beginning of having to deal with this. So we have a law called the Revised Uniform Fiduciary Access to Digital Assets Act. Daniel says we call it RFADA.
Yep.
RFADA. And this law was passed having to do with who can access digital assets. And in California, it applied to after death. And of course, what are digital assets? Your Google account, your Facebook account, emails, text, messages, you name it. And of course, everybody's moving to have everything online. So your fiduciary at death is your executor or your trustee. And the law said, how do you get into these assets if you're an executor or a trustee after death? This year, the law was expanded to include fiduciaries while you're alive. Who could that be? That could be your agent under a power of attorney. It could be a conservator. So you're still alive and somebody else needs to access your online accounts. So we now have a system for doing it. We call it a three-tier system. Number one, whoever you designated on the online tool is the first person up at bat. What do you mean designated? Well, if you look into your Google account, there's an area where you can designate. And the last time I looked at it is if there's been no activity for 6 months, I really should see, is it still that? But you designate who's authorized to access your account. So if the application has a way for you to make that election, that's number one. Number two, what do your estate planning documents say? What does your will, your trust say, your power of attorney? Who has access to electronic communications? And third would be what's the provider's terms of service? So when you sign up, you scroll through what are all the terms of service, who reads it, it goes on forever, and then you hit accept so that you can use it. Well, you've accepted the terms, and whatever that provider says is the rights of someone to get into your account, that's it. Beyond that, the idea of this law was to keep everybody out of court. But beyond that, arguably, you can go to court to get a court order to get access. I've not had to handle one of these cases yet. Uh, Last year, we had an estate finally where all the information was online, and the executor and heirs had no idea how to get into the account online. So there were no physical statements delivered in the mail. No one was really sure what did the decedent own. So this is going to become a bigger and bigger thing as we move over to a totally online world.
Yeah, and again, under this Rufata Act, it doesn't necessarily allow the person you named in your will or your trust or your power of attorney to really get access to your bank account necessarily, like by logging in through your account. Because banks, even though you're accessing your accounts online, it's not considered digital assets. So if in the event of your death or incapacity, no one can really sign on to your account, your bank account on your behalf. They would have to physically either go to the bank or contact the bank and use kind of the power of attorney or the will or the trust to access those accounts. And then, in a perfect world, you do your estate planning, everything is great. Your assets are titled in the name of your trust. Your beneficiaries on your retirement plans and annuities, those are all set up properly. Maybe you have a joint account with someone. Again, all of putting together your estate plan, one of the main goals, especially here in California, is to avoid probate. And so that's where if you were to pass away and the court had to get involved to supervise the distribution of your assets, that's what we call going through probate. And probate is really expensive. It takes a long time to go through. It's public record. And so many people's kind of main goal in doing the estate plan is really just simply just to avoid probate, along with all the other benefits you get from it. But of course, mistakes happen. You set up your estate plan in 2025. Hopefully, you live many, many years, decades go by. Maybe your assets have changed, the account numbers have changed, beneficiaries, you move from one institution to another, the beneficiaries didn't transfer, and you just pass away and you didn't really have all of your estate plan set up the way it should have been. Well, you could still be in a position of having some of your assets go through probate. And in California, we have lots of what we call summary probate procedures, where either you can go to court to get things handled quickly, so you're still going to probate court, but it's not the big probate that everyone thinks about, or you can sort of handle it yourself with just a couple of extra forms, compared to, again, if you pass away and all of your accounts are in the name of the trust, great. The successor trustee goes to the bank with the death certificate, copy of the trust, and they can get onto the accounts. But what if you pass away with just like a bank account that's in your name? It wasn't in the name of the trust. It's not held jointly with anyone. There's no designated beneficiary. It's just a pure individual account. And in California, the law says that if you die that way, that account passes according to your will. And hopefully, with an estate plan, you have what's called a pour-over will that says anything that goes through my will goes into my trust. Nice and simple. So in California, we have a procedure to collect that one bank account, that miscellaneous account, as long as the value of that account is less than $184,500, then it's just a simple form called an affidavit of small estate that allows the bank to just issue you the check. And again, if it's according to the will, the trustee can sign off on it to say this is a pour over will. And not that big of a deal. That account just gets transferred into the trust. That number of 184,500, it used to be 150,000, so that's a lot of people are still keep that number in mind, but it's gone up. Every 3 years, it'll go up with inflation. We're scheduled for another update with inflation in April of this year, so it could be closer to $200,000. But again, it's still a way to get miscellaneous things transferred without having to go through probate. And another summary probate procedure we have is, so that's what we call personal property, so like bank accounts or stocks and things. But what if you have real estate? This is a little bit different. There's different procedures. And the newest one is having to do with your primary residence. So this law just came into effect January of this year, and still it doesn't apply until someone has passed away until April of this year. So I think when the law was passed, they're going to give the courts a little bit of time to come up with a procedure to actually put it into effect. Where let's say I die and everything except for my house is in the trust. So my bank accounts, my investment accounts, I have an IRA payable to my kids, great. But for one reason or another, my house is not in the trust. Maybe it got put into the trust when I set up my estate plan, and maybe I did a refinance when the rates were really low, got it taken out of the trust, and I just never knew or didn't think about putting it back into the trust. Well, it used to be that that alone would cause a probate of the house. Again, really expensive and long process. But under this new law, as long as the value of my house on the date of my death is less than $750,000, then it does not have to go through probate, the full probate. There's a summary probate, which is a sort of a one and done type of thing, meaning I just submit this petition for succession to the court and I show them these are the facts. This was the house. Here's an appraisal of the house. It came in under the 750. And now if the court says, okay, this looks good, they can approve it. And whoever submits the petition, whether it's under the will or if there was no will, that the heirs, then the house can get transferred without the big, long, expensive process of going through probate and waiting to keep it open for a year and things like that. And so this is a brand new law. We'll probably have more to talk about it in the coming years. But a big question has to do with, well, what is a primary residence? And the law, it's a bit vague in that it says it doesn't have to be really the one you resided in. It allows possibly like if you had your house, but maybe you had to go to assisted living or a nursing home or something like that, that could still be considered your primary residence. And again, the main issue that we're going to have to keep an eye on is, well, what are the values of these properties? Is it possible that, still there are properties under 750,000 in San Diego, but of course, all over California, there's definitely properties less than that. And so we're able to kind of save the estate and save the heirs a lot of money by not having to go through a full probate. So now we have this extra tool in our toolbox. Of course, if the value of the property is very low, so now we're looking at this affidavit of small value. If the property, which could maybe be like a lot, maybe an empty lot somewhere, is under the $61,500, there's an even simpler procedure where still we just submit this affidavit to the court with an appraisal, and the judge doesn't even have to look at it. They just, as long as everything fits, it's just approved. And so there's lots of options for avoiding probate of maybe miscellaneous assets. So whether you have a personal property like cash or stocks, your primary residence, or even other real estate.
All right, here we see a young woman making an announcement. What's the situation here? Her father has become incapacitated. It could be dementia, it could be illness, it could have been an accident. She's the successor trustee of dad's trust. Now she has to step up to the home plate and take over for her dad. He's still alive, but he's incapacitated. Who does she have to notify? She actually has to notify all the beneficiaries of that trust that dad has become incapacitated. So imagine that if dad had died, it was going to go maybe to the 4 children. She now has to notify all of her brothers and sisters that dad has become incapacitated and they are entitled to see a copy of the trust to know what the assets are and to have an annual accounting to show what is she doing with these assets. So this is quite a change in the law that occurred a few years ago. So now not only does she have the responsibility of dealing with dad and his investments, she's going to get questions from her brothers and sisters. Why are you spending so much money on dad who's at this facility? Why don't you spend less? We can send him to, I don't know, someplace else. And so that trustee could be in the middle of a tight situation, but it is a duty that she has to notify the other people. An interesting wrinkle, if dad was found incompetent, which could be doctor's letters, a court order, depends what the trust says, she definitely has to do the notification. But if dad knew that he was kind of in declining health and resigned as trustee, she may not have this duty to send out the notification. And I have to tell you, this year I am seeing people over 100 years old. I'm not going to say every day, but there are lots of them. And it's been going on even last year. So people are living longer and longer. And I expect successor trustees are going to be stepping up and having to deal with trusts even while their parent is alive.
Okay, and we were sticking this part of the presentation back in. If you've watched it in prior years, hopefully this is not a surprise, but we're still coming face to face with people passing away, and then the children and their sort of the next generation being surprised about what happens to the property taxes. So again, if you're watching the presentation, likely you're a client of ours here in California, but we know there's many people watching outside of California. And if you're considering leaving California, this could be, just one of the nails in the coffin. And so, under our new California Proposition 19, there is some huge changes to what happens when you die, leaving real estate upon your death to the kids or grandchildren, and what changes with the property taxes. And so this law came into effect again February 16th, 2021. So anything that happened before that date, it's under the old law. Again, if those estates have already been settled, that's great. Even if not, some people have, the parent died, they just kept the house in the trust. They never really did anything with it because, maybe a child was living there paying the property taxes. Again, if the parent died that before February 16th, 2021, the old law applies. But for everything after the date, this new law says that a parent can transfer their primary residence to a child and keep the property taxes from being fully reassessed if the child maintains that property as their primary residence. So again, let's say you have three properties. You have your nice house and you have two rental properties. And let's say you have three kids. And so I have my house and the three kids. And upon my death, I want my house to go to one of them. And the other two can pick another condo and they can live in it. That's great. Under this new law, upon my death, the condos, even if the kids move into those properties, do get reassessed upon my death. So for property tax purposes, whatever the fair market value is of the house as of the date of my death, it's as if the child bought the house for property tax purposes at that amount. So it's about 1% of that is going to be paid in property taxes every year. Again, even if they move into the house. On my primary home, and I give it to one of my children, if they decide to keep the house and maybe rent it out, the property taxes get reassessed, again, as if they bought it for fair market value. But if they wanted to live in the house and occupy it as their primary residence, they can, and they can keep the property taxes from being fully reassessed up to $1 million above the current assessed value. So what does that mean? So let's say I bought my house many, many years ago for $100,000 and maybe now it's worth $2 million. So my assessed value of what I paid for it is the 100,000 and the fair market value is 2 million. So I die, I leave it to my child, they move into the house, they get the first $1 million excluded from reassessment. So the new assessed value is like 1.1 because you have the 100,000 plus a million. But now the difference of that extra $900,000 is reassessed for property tax purposes. So even in that best case scenario, that the child moves into my primary residence and lives there, the property taxes could still be reassessed, again, if there's been a lot of appreciation from really the purchase price or the assessed value. The important thing to think about is what are the deadlines? So again, as attorneys, we're always concerned, what are the deadlines? Could they be missed? The huge deadline is you have, for the child, if they're inheriting the parent's primary residence, they're going to qualify for the parent-child exclusion because they're going to live there and occupy it as their primary residence. They have to do it within a year after the death and file a homeowner's exemption form within that year. So again, just because the child inherits the property, they move in, if they don't file this homeowner's exemption form, the property taxes would still be reassessed. And so these are some of the issues we're dealing with. Again, sometimes it takes a while for when there's a change in the law, for issues to come up, and then for a person to come see us to see how we can help. But we're starting to see some of these where mom or dad died more than a year ago. Child maybe lived in the house the whole time or moved in afterwards, but they didn't file the correct forms, and they got this huge property tax bill where it used to be, the parent paid like sometimes $800 a year in property taxes. And now the child got a bill for $10,000 a year for property taxes. That's a huge change in what they were expecting. And so there's some really strict deadlines that you have to follow. And a kind of a common question we get in this situation was, well, how long does the child have to live in the house to keep the property taxes from being reassessed? And it's really the only while they're living in the house and occupying it as their primary residence do the property taxes stay suppressed from being reassessed. Meaning, let's say the child moves into the house, qualifies for the parent-child exclusion, pays the same property taxes that mom and dad were paying, and they live there for 5 years. Let's say they move out to buy another house, but they keep the parents' house. Since it's no longer their primary residence, the property taxes would still be reassessed when they move out. And as of last year, there's a little bit of kind of loosening of some of the rules where what if, again, getting back to what is the parent's primary residence? So they have their house but maybe they can no longer live there because they had to go to a nursing home or assisted living. And so now that there's this house that's maybe not necessarily their primary residence in that sense, under this new change in the parent-child exclusion law, it's still fine to qualify or to treat that house as their primary residence if the homeowner was in a hospital or healthcare facility. If they could have gone home, they would have gone home to that house. And if the property was rented, so this is a big question we get, if the property was rented while the parent was, not there, maybe there was no sense that they would be moving back, huge medical expenses, so why not rent out the house to pay for the expenses of the parent? If that person that was renting the house is a related person, then the property can still qualify for the parent-child exclusion upon the parent's death. But if they're not a related person, so you had to generate some money to pay for the parents' medical expenses, and it was just rented to a third party, the property doesn't qualify for their primary residence anymore, and so they don't kids wouldn't get the benefit of that new or the exclusion from the property taxes from being reassessed. And so again, from an estate planning perspective, we're thinking, okay, we know there's this new law, you're alive, I'm speaking with you across the table. First question we ask is, do the kids want to keep the property or properties? And so that's sort of a big question that a lot of people don't really have an answer to, but it's helpful for us to know, oh, by the way, maybe there is a child already living with me. Is there a plan for what happens upon, my death if they're still living in the house? And overall, again, as far as if the property is going to be sold, to let the parents know, there is this new reassessment that occurs the second you die, that property is reassessed back to that date. So even if, the plan is to sell the house, nobody wants it or it just doesn't make sense to keep it, the house will be sold. But what if it takes 4 months, 6 months, or a year to sell the house? In that case, the property taxes are reassessed back to the date of death. So for every month that they're owning before the property can be sold, if they have to clean it up and fix it up and things like that, they're incurring this new property tax rate at likely a much higher rate. So what if the kids or the parents think maybe the children, one or all of them, do want to keep the property after death? Well, from the estate planning side, we can include what's called a right of first refusal or an option to purchase. So basically, we're saying that in the estate plan, it can say, upon my death, to like my oldest child, if they want to buy the house as part of their share of the trust, meaning they don't necessarily have to, get a loan for $1 million to be able to buy the house with 20% down or something like that. It could just be part of their share of the trust that they're getting. But at least it lets everyone know that there's this right to, the first child or the second child, or there's an order so that if anybody does want to buy the house out of their share of the trust, really they can opt to allocate it as part of their share. And this helps minimize conflict among the children, again, if the parent is the one making these decisions. And there's something called these non-pro rata distributions. So again, depending on the total size of your estate after death, we look to see what's all there that's in the trust. Can the house be allocated to that child's share as the part of their, equal share? Or does some money have to come from somewhere else? If that is the situation where maybe my main asset is the house and it's worth $1 million, and my other assets in the trust are about $500,000 and everything's supposed to go equally to my two kids, if that one child gets the house worth 1 million and cash worth 500, not equal. If the child who's getting the house buys out their sibling to say, I'll pay you, the extra 250, so we each get an equal share of the trust, that does cause a reassessment in the property taxes because it's not a parent to child exclusion, it's a sibling to sibling transfer, which doesn't apply. So on the slide, it talks about these parent-child equalization loans. So instead of the child buying out their sibling, before the assets are divided within the trust, you can get a loan against the house. So essentially, you're pulling out equity of the house. So now the net value of the house goes down to 750. So there's the 500 of cash plus the extra 250 that they pulled out of the house for equity. And now they can divide it and it's an equal division. So there are some ways to do it either while the parent is alive and we come up with a plan, or after death in administering a trust to try to keep the property taxes from being reassessed. And to round it off, again, for future considerations, is if you are thinking of purchasing property or real estate, especially commercial property, working within the entities along with your children, there's a lot more options. So when we talk about this parent-child exclusion, this is really when property is going from like an individual or a trust to the children. But if you have like a partnership or an LLC, there are different rules and you have a little bit more flexibility. But it's important that you have to consider these rules before you purchase the property. So it all has to be done before you initially bought the property. Otherwise, you're kind of locked into it. And one of the questions we got, sticking with that Proposition 19 and parent-child exclusion rules, what if property is going to grandchildren? So there is, normally we talk about the parent to child, but right, what if there's grandchildren involved? The same rules would apply from a grandparent to a grandchild if that middle generation, the child, is deceased. And there's some other rules along that too, but you don't get the benefit of saying, well, I want my primary home to go to my grandchild. If my son is still alive, the parent of my grandchild, even in the situation where, the grandchild moves into the house and all that, doesn't apply if that middle generation is still alive. You can only do the parent-child exclusion. But thank you for the question.
Well, now we're going to start talking about retirement plans. And don't you just love the names of these laws? The Secure Act deals with retirement plans. You want security. In retirement plans, we're worried about what happens on distribution. There's going to be an income tax. Who's going to be taxed on the income? Well, number one, if you're still living, there are a set of rules. How fast do you have to withdraw the retirement plan? That's your required minimum distribution, usually based on your life expectancy. And now, if you're born after a certain date, you can defer taking your required minimum distribution. So if you're born in 1951, you can start taking it at 73. If you were born 1960 or later, you can defer it until 75. And deferral is great because then the retirement plan keeps on growing without current tax. And now somebody's going to say, but what about Roth IRAs? And you're right to talk about Roth IRAs. Those do not have income tax on withdrawal. They grow completely tax-free. It's just a matter of when must they be withdrawn. So not during your lifetime, not during your spouse's lifetime. But let's go to the next slide. All right. Now we're going to talk about what happens at a death. So now we have a whole set of rules that we have to worry about. The rules tell us when must distributions be taken out. And if it's a Roth, again, no income, but that Roth is ending. If it is not, if it's your normal IRA, your 401k, your pension plan, that money, when it comes out, is taxable income. So here we have the three rules that we have to pay attention to. If I die and I leave my IRA to my children, how long do they have to withdraw it? I'm going to bounce you down to the last rule, 10 years. So within 10 years, that IRA must be withdrawn. And during that time, they have to take required minimum distributions. And our thinking used to be, why not just wait till the last day to take the whole balance out? The reason is in that last year, there'll be such a huge amount of income, it'll be taxed at a very high rate. So my children would probably consider taking maybe 1/10 of it in the first year, another 10th in the second year, so that by the end of the 10 years, it's all withdrawn. So lots of people are going to fall within the 10-year rule. Who still gets life expectancy? If I make an IRA payable to my spouse, the spouse can still use their life expectancy for withdrawals, which is usually pretty good. It might be more than 10 years. A minor child can use their life expectancy until they reach majority. Then they get 10 years. If someone is disabled or chronically ill, so if your beneficiary is having a problem, severe medical problem, they can use life expectancy for withdrawals. And if the beneficiary is less than 10 years younger than me, who would that be? That would be my sister. So if I leave an IRA to my sister, she's less than 10 years younger than me, she can still use life expectancy for required minimum distributions. It can go on for a long time. Who gets a 5-year withdrawal period? That we call the worst of all things, because if there's only 5 years, the income must be recognized within 5 years. If you make your IRA payable to your estate, don't do that. Name real people, then they get 10 years. If there's no beneficiary on your IRA, which would be very unusual, usually it is set up with a beneficiary, or if you named a beneficiary but they have died, now there's no beneficiary. Be sure to name a second beneficiary. So even if I name my spouse as first beneficiary, I'm going to name my children as the second beneficiaries. And if I leave it to a trust, which is not a see-through trust, there's a 5-year withdrawal period. So if you're going to leave your IRA to a trust because you want it managed, you want it protected from the creditors of the beneficiary, that trust needs to be drafted in a very specific way so that the IRS can see through the trust to who the real beneficiary is. So we have to be very careful on those. And the take-home message, because we see this every day, I ask people, who's the beneficiary on your retirement plan? Oh, I don't know, or I think I named them. I'm not sure if I named them. Well, your beneficiary, the designation that you put on that plan, wherever the plan is, it could be Schwab, it could be Fidelity, it could be Vanguard, etc. You're filling out that institution's form. That is your designated beneficiary. That's like a will for your IRA. Keep a copy of it. It's a really important document, and you need to know who did you name so that you get they get the longest possible withdrawal period.
Yeah, and nothing we prepare can change the beneficiary of your retirement plans. So it's really important that we talk about it or that you check who was the beneficiary. If it needs to change, you fill out on the bank's forms. Okay, so thank you all for sticking with us to talk about taxes. Now, this part of the presentation, we go over sort of some cases that have come out in this last year. And again, from an estate planning perspective, we're always thinking, okay, these cases, probably the person that died, usually, they probably died maybe like 5 or 10 years ago. And so they've been in litigation this whole time until these cases come out. And what could we have done from an estate planning perspective to avoid our client from having to be in these situations? We always joke that you never want to be part of our presentation, but it's just every year there's always something new or a little change in sort of the trends, how things are going. And so in this first case, we're talking about omitted children. So again, in California, you could say that upon my death, even though I have 3 kids, I only wanted to go to the 2 of them. I'm estranged from the other one. For one reason or other, they're too rich. They don't need the money. I'm just going to leave it all to the 2. Great, you can do that. And in the estate plan, we would talk about it. And that's why we're always asking you, who are your heirs? Do you have kids? All these things. So that if for some reason you don't want to include them, we just have to say it, saying, I know I have 3 kids. I'm not including one of them. Great. That you've consciously omitted to provide for that child. But there's always the case where what if you have, some children that you didn't know about? And so this is what happened in the estate of Williams matter, where the decedent had 7 children from various women. He only knew of 6 of them. So one of them was, I think in the case, called like a one-night stand. And so he never knew that this child was born. But he did know that his other 6 children were born. The last two were born during his marriage with his spouse. And so in his estate plan, he said, I know I have these six kids, and I'm only providing for these two of them. So, of course, he died. But the child that he didn't know about, her name was Carla. She did actually her child did a DNA test to find out, who's my family members, and was matched with all these people that she didn't know. And we're seeing a lot of that these days, where people find out through these DNA matches that maybe they do have some relatives that they thought were relatives that aren't, or are not their family. And so, based off of the DNA match, the grandchild, met all these family members and then told their mom, Carla, oh, by the way, did you know this is your real dad? And at some point, Carla, after her real biological father passed away, filed a lawsuit against the estate to try to say, I should be receiving an equal share of the estate. He, in this estate plan, don't know why, but did not include what we call a general disinheritance clause. So again, even every estate plan that we put together, we say, these are my children. I'm including all of them, or none of them, or one of them. And then later on, we would say, by the way, if for some reason I didn't mention someone that is an heir of mine, so like a child I didn't know about, they are automatically excluded, and I intentionally did not provide for them. So we call this the general disinheritance clause. Just for these situations, in this estate plan, the Williams matter, he did not have the general disinheritance clause. So Carla tried to sue to say I should have gotten my share. I wasn't omitted. He didn't know about me. Under California law, she could have been entitled to receive. But in this case, very specifically, because the decedent did have six children and he knew he wasn't providing for four of them, the fact that Carla was not included, the court said, was not the sole reason that she was omitted. So she couldn't say, oh, he provided for all six of them. I should be part of that too because I'm the seventh. In this case, he knew that he was omitting to provide for some of his children. So Carla was not able to receive her share of the inheritance. The court's reasoning was, well, even if he knew about her from his current estate plan, he likely would have omitted her and just included the two children that he wanted to receive from his estate. Again, you don't want to rely on that because that's not always going to be the outcome, but that's what happened in this case.
All right, our next case. Oh my gosh, the attorney was sued. The estate planning attorney was sued. It's a very upsetting situation. What happened in this case? A man with a really significant net worth, $18 million, originally was going to leave half of his estate to his son and the other half to the grandchildren of the other son. He was omitting the other son. He thought the other son really didn't know how to handle money. And that's what he told his family. Half of it's going to my son, the other half's going to the grandchildren. That's not what he told his lawyer. He told his lawyer, I want everything to go to my fourth wife. Now, this was not a situation, I think, where the wife was trying to get the estate. She had $100 million estate of her own, but he wanted everything to go to her. She'll figure it out. She'll decide what's fair. She can do whatever she wants. And the estate planning attorney, boy, did I read this case. The estate planning attorney was deposed and said, did your client know that he was omitting his family? And he said, definitely. And the estate planning attorney was a certified specialist of 30 years and all kinds of things that he definitely knew. He wanted to leave it to the fourth wife. It was not going to go directly to the family. He didn't tell his family this. So after he died, everything goes to the fourth wife, and now the family sues the attorney for being negligent and not including the son and the grandchildren. And the court had to decide, well, in this situation, who does the estate planning owe the duty to? The duty is owed to the father, to the client, and the attorney has to pay attention to what did the client say. They're not there to protect these other beneficiaries who dad never told. I wish dad had told them about it. And so that's a very nerve-wracking case for us attorneys. And I know we have attorneys on the Zoom. So what can we do as attorneys to try to make sure everything goes to the right place and also protect the estate and protect ourselves, that if later on somebody contests, how do we prove the intent of the client because the client's not there. The client is dead. I keep telling my clients, you won't be here to explain it. All that will be left is maybe a letter that you left in your own handwriting. This is what I try to get. I try to get my client to put in their own handwriting, I am omitting to provide for these people. And sometimes that's a very sobering experience, and some of them change their mind. But we want to get that in writing. As we go into our digital age, who knows? Maybe we'll do videos, even though those have some drawbacks. But there needs to be a clear record. And when we're meeting with clients, we're very specific about I need to make a family tree. I need to know who are your heirs. I mean, you may be telling me everything's going to Susie. I need to know, do you have children? Do you have children who died, who left children? If you don't have any children, who are your brothers and sisters? Are your parents living? And I nag people, I need to have this family tree because the people on that family tree, if they can overturn the trust, will inherit as what we call intestate heirs under the default laws of the state of California. So I can't tell lawyers, you're never going to be liable, will never be liable, but it's important to make a really clear record of what was the decedent's intention.
Okay. This next one talks about who has standing to sue. So again, this is sort of an overall lesson of what happens after the death of someone and what lawsuits could arise from it. So in this matter, there was a doctor, Dr. Head was her name. She became very ill. After she left the hospital, she went to live with a former student, sometimes a red flag here, who ended up being somewhat of a caretaker. And so the doctor signed a trust, naming the student as the trustee and sole beneficiary. And this went against the prior estate plan, which the doctor had everything going to her sisters. And of course, 2 weeks later, the doctor died. And under the trust, it said everything goes to my former student. But in this case, the sisters sued the trust or sued to invalidate the trust, saying that there was, undue influence. She didn't know what she was doing. There was fraud. There's all these, reasons people give for trying to say, oh no, that document shouldn't be looked at. In this case, the sisters sued under a very specific probate code, which is not normally the one you would file a lawsuit under. And so really the court had to determine, well, in a way, even though they didn't use the right probate code section, do they still have standing? So can they still sue based on this probate code that they're going off of? And in this case, the court did say yes, because the sisters were what's called intestate heirs. So in yours, let's say you don't have an estate plan, so you're just, you're out there living your life, no will, no trust. You still have your heirs. In this case, if you don't have a will, they would be called intestate heirs. So essentially they are your heirs by default because you didn't say where your assets should go through a will. And so the sisters in this case were the intestate heirs. The doctor was not married, had no children, parents weren't alive, so the next of kin were the sisters. So if the doctor died without having a will or anything, the sisters would have inherited everything. And so in trust administration, that's sometimes a big surprise that where we talk to people to say, well, now that, mom or dad or so this person has died, one of the first duties that you have is a duty to notify all of the beneficiaries of the trust. So you give them a copy of the trust, you give them a letter saying I'm the trustee. Within that letter, it actually has language that says, now that you've received this information, you have up to 120 days to contest the terms of the trust. So all the beneficiaries really get a copy of the trust in this letter saying if you don't like what it says, you have 120 days to file a lawsuit to invalidate the trust. Not only do you have to send that notice to the beneficiary, so the people named in the trust, but also your intestate heirs. So if you did have, again, 3 children, one of them is not included, they would have been my intestate heir, but I leave everything to the 2 kids. Upon my death, my trustee has to give that notice to each of the 3 children. So even the one that's omitted gets a copy of the trust and an opportunity to object to the trust. And so this is, again, very important when we're meeting with clients. If they're omitting an intestate heir or even changing their share of, instead of 50-50 to the 2, it's 75-25 or something, that we keep really good records and that we make sure the client knew what they were doing. Sometimes if the child, comes in with the parent to make some changes, we'll have the child step out of the room so we can say there's not, any undue influence. So again, as an estate planning attorney, we're very conscious of making sure that if you're changing your default distribution plan that would happen otherwise, that we keep a really good record of it and you know what you're doing.
Well, we're going to talk a little bit more about undue influence. And we're talking about what effect does it have in a lawsuit? So if a client comes into me and says, I want to leave $50,000 to my caretaker, Mary, boing, a little light bulb goes off because there's a law in California that any amount left to a caretaker is presumed to be the result of undue influence. So if, let's say, the children want to contest and they say the money that's going to Mary was procured under undue influence by Mary, they just have to say it. They don't have to prove it. Mary has to prove that she did not unduly influence the person into making the gift. So we say that this presumption of undue influence changes the burden of proof in a lawsuit. Who has to prove it? So anything going to a caretaker is problematic. We have a law in California that if it is going to a caretaker, I can tell my client, I will write it in, but I need you to go to another attorney for a certificate of independent review, where the other attorney meets with you and decides, are you or not under the undue influence of Mary? And if you get that certificate, boom, that brings the burden of proof back to the family instead of the caretaker. Oh, it's back and forth, depending on who is being given this bequest. Is it a caretaker? So here we have a case, happens to be called Robinson versus Gutierrez. What happened here? The elderly person gave free room and board to a caregiver. The deal was, come live with me, you take care of me, and you don't have to pay room and board. You can still live your life, but you're living with me and you have to take care of me. The decedent signed an estate plan, making the caregiver the sole trustee and the sole beneficiary. So there were other family members, but she decided, I'm going to leave everything to the caretaker, with the caretaker in charge. And 10 days later, she died. I'm so tired of seeing these facts where it was done right before death. It looks terrible. There was a suit to invalidate the distribution to the caretaker, saying this was a care custodian. And if it is a care custodian, then there's this presumption of undue influence. What did the caregiver say? I didn't receive any payment. So because I didn't get a payment, I was not a paid care custodian. Well, the court decided that free room and board counted as a payment. There was no way out of that. So the lesson to us as attorneys, sometimes we're the wall between the client and their caretaker when it comes to undue influence. We've had situations where people come to us with their caretaker in the lobby. And I say, I have to meet independently with the client. I'm sorry if it offends you, but you cannot be part of the meeting. You have to just sit out there or go away for a while, because it's up to us to try to decide, is this person being unduly influenced? And sometimes it's very hard. Sometimes we can see that the client has limited capacity, or they're under pressure, or they're nervous. And we just want to spend some time with that person to see, how do they really feel about this? Are they sure they want to do it? What did their estate plan say before? So leaving funds to a caretaker is really a hot potato in the law. Daniel.
And the next case is Godoy versus Linsner, and I'm very happy that this came out as part of our presentation today, because this is something that, in a way, we're dealing with a lot more frequently these days. Basically, having to do with real estate in a trust. So in this specific case, mom had her house, and she wanted to keep the house in the trust. She wanted to keep it in the family, really. So for as long as possible, she wanted to say, even though I die, I want all my kids to be able to benefit from this house. I don't care how they do it. They could all move in together. One of them could move in, pay rent to the other. They could rent it out. I just want the house to be kind of held within the family as long as possible. And we see that more and more frequently these days, especially again with sometimes that the main asset of your estate being the house, or you've realized, oh, if this house is sold and divided among my three kids, they could never afford to buy a house in San Diego or California again, and they'd have to move out of state. I always want them to be able to say, I have a place in San Diego or where I grew up so that I can live there. And so in the estate plan, the mom said, okay, upon my death, the house stays in trust. Not a big deal. We've done that before. All three children are beneficiaries. That's fine. And so, working with her estate planning attorney, she came up with a very thoughtful plan. But eventually, the mom said in a handwritten amendment to her trust, which is something we're always concerned that people are going to be making these changes on their own without maybe talking to an attorney or just, writing it out themselves. And maybe it was like their thoughts, not necessarily an effective amendment, but they put it in their own handwriting, signed and dated. Maybe it's treated as an amendment. In this case, the mom said, any of my children can sell their house. It has to go to one of the other children. So that's like, a right of first refusal. Not that big of a deal. But in this case, the mom said, the child's share can be sold for no more than $100,000. So again, in this case, if the house was worth maybe $900,000, each of their shares really are worth about $300,000. They each get a third of it. But the mom said, nope, it has to be sold for $100,000. And so, of course, in this case, after mom died, one of the kids wanted to keep the house, the other two didn't. And so the ones that didn't want to keep the house said, this isn't fair. Why should I have to sell my portion to the sibling for only $100,000? If we were selling it on the open market, we could sell it for $1 million and I would get $300,000. And so they actually did sue the trust to say this amendment is not valid. In this case, under what's called an unreasonable restraint on alienation, basically saying you can't make it so difficult for me to sell the property that I'm not going to do it. So again, clients come to us all the time and have ideas of doing something similar to say, no matter what, the house can never be sold. And we tell them, you can keep the house in the trust, and the kids can all be the beneficiaries of the trust, but you can't prevent the house from being sold. If the house is sold, the sales proceeds can stay within the trust. So now it's still one pot of money and the kids can use it for their needs, but you can't prevent the assets within the trust from changing, whether it's like stocks, real estate, things like that. And so in this case, the court agreed, said, yep, this is an unreasonable restraint on alienation. This amendment is invalid. And so the house could have been sold, even still to the siblings, but for full fair market value. So again, when clients come in to see us and they have this idea of trying to keep the house in the trust, we'll try to think it through as much as possible. And we'll say, can we put, the right of first refusal, so it has to go to a sibling, but should we have, it says it has to be an appraised value, so there would be an appraisal. Are we going to take into any considerations, maybe foregoing the cost of sale? So this is a big thing that comes up. Again, if you don't have a plan, unfortunately, sometimes you have to negotiate with the beneficiaries and say, well, this one child wants the house as part of their share of the trust. And, if the house was going to be sold, even with all the real estate commission and expenses and all that, your one-third share of the sales proceeds would have been maybe 150,000. So that's what the house should be valued at when it goes to the other child. And of course, the one child said, well, we're not selling it. There's no costs. So without all those expenses, my one-third share should be 200,000. And so again, we can put this into the estate plan. And there are ways to try to keep the house, in the trust for as long as possible, maybe a generation or more. But again, we have to be very cautious to make sure that we don't end up in this situation where the whole thing could, be voided because we didn't do it right.
In our final case, the Asara case, we have a situation where there's a trust. There were these two beneficiaries, and one of the beneficiaries was also the trustee of the trust, but he was a bad trustee. And the bad trustee committed financial elder abuse, took money out of the trust that should not have been taken out. So the other beneficiary was very upset. You reduced my inheritance, sued, and the court agreed that there had been a fraud, and this trustee needed to put back the original amount that was taken plus twice, that's double damages. So the original amount plus twice that amount had to go back. The beneficiary said, I don't want it to go back to the trust because the bad trustee is going to share in that trust. Why should the bad trustee get anything out of that trust? And the court agreed. The court agreed the wrongful trustee shouldn't get anything, and the double damages were awarded entirely to the beneficiary who brought the petition. So that was very fair. Daniel, could you wrap up now? Thank you, everyone, for paying attention for so long. What are the takeaways from our presentation?
Yeah, we really appreciate you, watching us for the first time or coming back every year. I know we have lots of people that will come watch these presentations and they still, don't need to update their own estate plan, but, on an annual basis, they just want to know what's going on. So we really appreciate that. So what are the takeaways? Again, the biggest one really is the sunsetting of this estate tax exemption amount. So for large estates, again, if you're over potentially 7 million assets per person or 14 for a married couple, there's this huge tax that could be you could be affected by. Again, whether you die, if a difference between this year and next year could be millions of dollars worth of taxes. And so it's definitely something to consider. Talk to your estate planning attorney, your financial advisor, your CPA, and think, do I need to do any planning? And of course, if you did have a spouse that has died in the last 5 years, again, consider filing the estate tax return for portability purposes. Income taxes, again, big deal is if you have these irrevocable trusts like the AB trust, is that something you still want to keep? Likely, maybe not something we would necessarily try to get rid of until maybe we know if there is going to be a new tax law, depending on the situation, but still worth talking about. Electronic signatures, again, make sure your documents are signed properly. Last year, our big part of our presentation had to do whether amendments were made properly. And so even just getting back to the basics of changing documents or signing documents, it's still very important to make sure they're done properly because you'll see every year we still have these cases that come out about it. Again, transfers without probate, hopefully you're not in that situation, but if you are, there are, as opposed to just saying, okay, I need to do the big, long, expensive probate, maybe there are ways to avoid these a full probate. Let's see. Property taxes, retirement plan, IRA, inheritance taxes, things like that. Again, really important to keep in mind that even if you don't necessarily need to change your estate plan of changing who's the trustee or the beneficiary, are you aware of the tax implications of dying? Because those have been changing over the years. And of course, with our cases and everything, the big deal is make sure that you're clear on your intent. So again, people always think, we're here to just write down what you tell us to write down and make sure it's legal. But there's a lot to it. We have to sort of know you had capacity to make the changes and we knew what your intent was and that we keep a record of it because sometimes people don't necessarily like to tell the family what's going on within their estate plan. And they may say one thing, to their kids and a different thing to us. And of course, that can cause a little bit of issues. And so again, also planning about the family home. So again, this is a huge trend that we're seeing where kids are living with the parents, and then what if that parent dies? What's the plan for the child living there? And is the house going to be sold? Can it stay in the family? What's the plan? And then Roberta, do you want to talk about our next presentation?
Well, we try to prevent problems, and one of the ways is to educate people who are trustees or who may become trustees on what are they supposed to do? What are their duties? So we're going to have another presentation coming up later this year, and we'll send out an email announcement that is just going to focus on the duties of a trustee, how to keep your records, what do you do about taxes, how do you communicate with people to keep people on the straight and narrow so that hopefully you don't wind up to be, as Daniel says, one of the cases in our annual presentation. So thank you very much for attending. And of course, you can email, you can call us. And Daniel, you're going to be emailing a copy of all the handouts and the link to the recording afterwards.
Right?
And we invite you to go ahead and share these if you want to forward it to your friends and family so that they can think about it. Feel free to share it. Any final words, Daniel?
No, thank you, everyone.
All right,
Have a good
thank you.
year.